Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Good morning. My name is Jim Santel. Welcome to our weekend review, our analysis and our discussion of the most important stories in law, in government, and the aspiration for justice in America. Going to be pursuing that broad agenda again this morning, a special edition this morning, December 3rd, 2022 of Morning Cannolis. Why? Because this is our 25th show this morning. We're finishing up and beginning a next 6 months, finishing up 6 months, starting a next 6 months, perhaps beyond that, of Morning Cannolis every single Saturday morning from 9 o'clock to 11 o'clock. And always this morning, as in the past, taking your phone calls at 844-967-2789. I am here in the Civic Media Studios of the Shaw in Waukesha. That's 540 AM, 101 FM. I'm here with my highly professional and always engaged producer, Kelvin. And together we are taking your phone calls, your observations, your comments, and your questions this hour and again next hour. Because this is a special day, a special observance, our 25th show, the conclusion of our first 6 months on the air of Morning Cannolis. We're going to adopt a slightly different agenda this morning. Always ambitious, but always achievable. And so this morning, unlike in past mornings, we're going to dispense with our discussion of what happened in history and go right to some of the major news stories. We're going to start with a couple of stories that comment on the rule of law in America, coming out of our courts once again, our federal courts in particular. And then at the end of our second hour, we're going to finish up with what's going to be coming up this coming week before the United States Supreme Court. Two major cases also in the area of the rule of law, one having to do with civil rights, the other having to do with elections and voting in America. Who decides elections? Who decides about the voting processes and procedures? Both of those cases coming up this coming week in the United States Supreme Court in Washington, D.C. We're going to finish up our time together this morning talking about those with some special commentary from me about their meaning. We're going to begin again with special commentary, thoughts on two significant events this past week, again, coming out of our federal courts. We're going to begin with this major ruling coming out of the 11th Circuit Court of Appeals. This, of course, one of the many courts of appeals in America, just below the highest court in the land, the United States Supreme Court. And obviously an in-between court, if you will, between the district court, the trial court, and that highest court of all. We know that this past week, a federal appeals court in Atlanta, that is coming out of the 11th Circuit, removed a major obstacle to the criminal investigation into former President Donald Trump's hoarding, his taking, his acquisition, perhaps his use of government documents that ended an outside review of thousands of records that were seized by the FBI from his home in Mar-a-Lago, his office in Mar-a-Lago, and effectively freeing the Justice Department and the newly appointed special counsel, a fellow named Jack Smith, to use them as he and his staff goes forward with its inquiry into whether or not there have been violations of law, the Presidential Records Act, the Espionage Act, other particular federal statutes that have been the subject of that investigation. We're going to talk this morning. I'm going to, again, depart from our normal procedure this morning, not talking about past history, but present history, and providing you with some specific, very articulate expositions by the 11th Circuit judges about the rule of law. And the point of this is if anybody today is still concerned about the legitimacy of this process, about the application for the search warrant, about the review by judges, the analysis by the Department of Justice, this 21-page memorandum, this 21-page order from the Court of Appeals effectively puts all of that to rest. It is a great read. It is accessible. It is understandable. And the judges, the three judges, about whom we will talk more in just a moment or so, have done a superb job of providing yet another lesson in civics to all of us in America. And it's for that reason that I'm spending most of this first segment talking about that major case coming out of the 11th Circuit just this past week. It's a unanimous opinion. It's unsigned. It's 21 pages, as I said. A three-member panel of the Court of Appeals in Atlanta shutting down this lawsuit that was litigated by former President Trump basically stopping for at least three, perhaps even 4 months, slowing this inquiry into whether he illegally kept these national security records at his Mar-a-Lago residence and obstructed the government's efforts to retrieve them. You will recall from our past broadcasts, our past discussions about this, that a part of the released affidavits suggested that there was obstruction along the way, something that's often forgotten in our focus on this case. The appeals court, as you will hear this morning, sharply critical of the decision way back in September, about a month after the search warrant was initially issued, by Judge Aileen Cannon, C-A-N-N-O-N. She was a judge who sits in the Southern District of Florida. Again, that's the lower district court in Florida, to intervene in this case at all. The court, as you're going to hear, basically said that Judge Cannon never even had a legitimate jurisdictional basis, the power, the authority to order the review or bar the investigators from using any of these files. No justification, they said, for treating Mr. Trump differently from anybody else in America. And that's one of the two major takeaways. That is, the former president is subject to the same laws, the same rules, the same restrictions as all of the rest of us. No one above the law. And secondarily, that this entire process, this entire civil challenge to the legitimate criminal investigation that's been pursued, frankly, for a couple of years now, all of that was baseless and without jurisdiction. So let's talk about what exactly it is that the Court of Appeals has done. And yes, I'm going to provide you this morning because it's such good writing. It is such a wonderful exposition of the process here, beyond just the specifics here, that everyone needs to hear this and everyone needs to understand it. The opinion, once again, very much accessible online, easily accessible. This comes from the Chief Judge of the 11th Circuit Court of Appeals. His name is Pryor, and along with a couple of other judges named Grant and Brasher. All three of the judges issue what's called a per curiam opinion, P-E-R, new word, curiam, C-U-R-I-A-M. What does that mean? Basically, it means that the judges issuing this order in unanimous agreement. Even with a three-judge panel from time to time, you will have a dissenting judge. And here, these judges, looking at this case, as we know for a second time, come to the decision unanimously. No disagreement here at all. The things we're about to say in the next 20 pages that they have written are in agreement and state with great exposition exactly what they wanted to say in concert with one another. They say at the very start, provide some basic background into all this. Said this appeal requires us to consider whether the district court, that is Judge Cannon, had jurisdiction to block the United States from using lawfully seized records in a criminal investigation. And here it goes. This is the second sentence of this major opinion. The answer is no. Couldn't be more clear on that. Couldn't be more explicit in the rejection of virtually everything that the lower court has done in this case, including entertaining this case from the get-go. Goes on to say these disputes ignore one fundamental question, which were raised by the parties: whether the district court had the power to hear the case at all. After all, federal courts are courts of limited jurisdiction, the court goes on to say. They possess only that power authorized by the Constitution and statutes, which is not to be expanded by judicial decree. This case was such an expansion. That is a real statement to the lower court that what you have done is a power grab, if you will, sort of in colloquial terms, and plainly indicating, as the judges went on to say, our precedents have limited that this jurisdiction is subject to a four-pronged test. We're going to talk about that this segment and the next segment as well, because again, great exposition about the things in which the court wrestles in coming to this conclusion. In considering these arguments, that is the arguments of the parties for Mr. Trump and by the government, the United States Department of Justice, the court went on to say, we're faced with a choice. We have got a choice here. Goes on to say we can apply our usual test, which is applicable to every single American citizen, regardless of their statute, or drastically expand the availability of equitable jurisdiction for every subject of a search warrant. In other words, if everybody has this opportunity to come in, we can do that as well. Or we can carve out an unprecedented exception in our law for former presidents. Those three, those are the alternatives. And the court goes on to say, we choose the first option, so the case must be dismissed. And again, in the following pages, basically pages 3, 4, 5, 6, 7, 8, and 9, a huge amount of exposition, much of which has been in the news, about how this case got to the 11th Circuit Court of Appeals, what happened at the lower court, and in particular, all of these efforts made between the time that Donald Trump left the White House in January 2021 until now to try to get back the National Archives, trying to get back the records that he took, regardless of whether they're classified, things subject to the Presidential Records Act, attempts made by asking, writing letters, filing requests with counsel for the former president, seeking and getting a subpoena from a grand jury to produce those. In response to that, the Court of Appeals opinion goes on to say, an exposition by the attorneys for Donald Trump that we've complied with all of that. We've responded to all of that, which again, we know is not true. And again, during the course of this initial exposition of the facts behind all this, the court eventually says, even as this attempt to recover all these documents is going on, the Department of Justice and the FBI in particular continuing to assemble evidence that indeed there are still more documents that have not been produced voluntarily, subject to the subpoena, subject to request. And for that reason, the United States Department of Justice went to a federal district court judge and secured a search warrant for the search and the seizure of materials at Mar-a-Lago. Goes on to describe, in fact, the specifics of that warrant issued way back in early August that legally justified under the Constitution exactly what happened here, and describes all of that, and ultimately notes that on August 8th, it's just been that long, August 8th, the FBI executed the search warrant, about 13,000 documents obtained, even after months and months of attempt to get all those back, 22,000 documents altogether, including about 100 so-called confidential documents marked secret or top secret. And again, the court goes on to say that as it reviews all of this matter, including the civil request to basically stop the investigation for the appointment of this special master, there are standards to be applied. And the court articulates those and goes through in the following 20 pages the specifics of that. Right after the break here, we're going to be talking about exactly what the Court of Appeals said and what it didn't say in this shutdown of this major civil litigation, also telling the lower district court judge that she was wrong from the start. Stay with us here in Morning Cannolis as we discuss this major case in American jurisprudence. We are back. We are talking this morning, Morning Cannolis, December 3rd, 2022, about a major decision issued just this past week by a major appeals court in our land, bringing to an end these months of civil litigation initiated by the former president to stop the investigation of the Mar-a-Lago case, to stop the investigation by the Department of Justice, determining whether or not there were any criminal crimes committed as a result of the taking, the acquisition, the possession of those documents at the Mar-a-Lago residence. Just before the break, I was providing some information about this wonderful opinion, which is in itself a tremendous civics lesson for all of us about how courts work and about the kinds of things that they bring to the analysis, which the 11th Circuit did in this case in shutting down the former president's claims that somehow he is being mistreated, that the Department of Justice is behaving in a way that's inappropriate with the Constitution or with the laws, and the Court of Appeals will have none of it. Also along the way, finding that Judge Eileen Cannon, in her appointment of a special master, a judge named Raymond Deary out of Brooklyn, all of that improper from the very start. And the Court of Appeals cutting through many, many initial arguments by the parties and saying there's a fundamental notion here that we've got to address that takes care of everything else, and that is that there's no jurisdiction. A civil court, the appeals court finds, has no jurisdiction to enter into this fray, to review these kinds of things, noting again in the middle of its opinion as it gets into its analysis that only the narrowest of circumstances, the court says, permit a district court to invoke what's called equitable jurisdiction. And lots of this language proceeds upon that fundamental notion. Decisions must be exercised with caution and restraint, as equitable jurisdiction is appropriate only in exceptional cases where equity demands intervention. What does equity mean? Well, usually it's the kind of the quality of fairness or impartiality. It's kind of what we think about in the normal sense of that word. Remedies and procedures in a civil case different from the statutory, maybe constitutional standards would otherwise apply, ensuring that fairness is done, that something is accomplished in an impartial way. That is the invocation, if you will, by the attorneys for the former president, and also by Judge Cannon, who is struggling along the way to find the basis for her to act in this case. Again, the Court of Appeals rejecting those. It goes on to say it is a familiar rule that courts of equity do not ordinarily restrain criminal prosecutions. And that's in page 11. You could basically stop the opinion there if you would like to, but the Court of Appeals does take seriously all of the arguments presented by the former president to avoid unnecessary interference with the executive branch's criminal enforcement authority, the Court of Appeals goes on to say, while also offering relief in those rare instances where a gross constitutional violation would otherwise leave the subject of a search without recourse. In other words, equitable jurisdiction only where some extraordinary needs, some extraordinary intervention by judges is required. This circuit, the 11th Circuit, as have most other circuits in the country, this circuit, the court goes on to say, has developed an exacting test for exercising equitable jurisdiction over suits flowing from the seizure of property. It's called Ritchie versus Smith, R-I-C-H-E-Y. The court refers to this as Ritchie throughout its extensive, but once again, very accessible and understandable order. 4 different standards, and here they are. We're going to talk about them each very briefly, much more exposition, much more wonderful articulation in this great opinion. Here are the 4 standards that the court applies in determining whether or not it's got equitable jurisdiction to even hear this case in the first place. And again, spoiler alert, not too much of a spoiler in this opinion because it's announced from the very first pages, no jurisdiction here at all, no power, no authority. The standards are these: where the government displayed a callous disregard for the plaintiff's constitutional rights. That's number 1. Number 2, whether the plaintiff, in this case Donald Trump, has an individual interest in and need for the material whose return he seeks. That's the second standard. The third one is whether the plaintiff would be irreparably injured by denial of the return of the property. And fourth, whether the plaintiff has an adequate remedy at law for the redress of his grievances. And most of the remainder of the opinion takes each one of those in order and determines whether or not there's any any basis for finding that any one of those standards has been met here. The court begins to say in its first exposition of each of these standards, the plaintiff makes arguments that, if consistently applied, would allow any subject of a search warrant to invoke a federal court's equitable jurisdiction. And that, once again, underscoring this notion that no one is above the law. If we permit jurisdiction in this particular case, then everybody who is subject to a search warrant, subject to seizure under the 4th Amendment to the Constitution, would have this access. And I should note, as the Court of Appeals does, that there is a remedy here. There's a remedy after someone is charged in a federal court, after someone is indicted by a federal grand jury, and this evidence is going to be used against them in a trial and other proceedings. It's at that standard, at that stage, that you can, in fact, ask for the judge to review the results of a properly executed and issued search warrant. That's what the court is basically saying. We're not going to open up the doors to all of those kinds of things, especially since there is a remedy already available to you. Court goes on to say, we'll begin with whether or not there was a callous disregard for the president's constitutional right. The callous disregard standard has not been met here, and no one argues otherwise. That's on page 13. District Court's entire entire reasoning about this factor was that it agrees with the government that, at least based upon the record, there's not been a compelling showing of callous disregard, dismissing that first standard out of hand very, very summarily, very quickly. Nobody disagreeing about that one. Second factor, where the plaintiff has an individual interest in and need for the material whose return he seeks. What about this claim that he's got a personal, private interest in these materials? Goes on to say very clearly, plaintiff, that is former President Trump, has made no such ruling. His jurisdictional brief in the district court asserted that the government had improperly seized his passports and that his continued custody of similar materials was both unnecessary and likely to cause significant harm. The district court goes on to say, the appellate court goes on to say, the district court was undeterred by a lack of information, a lack of basis there. It said that based upon the volume and nature of the seized material, the plaintiff has an interest, and at least some interest in a portion of it. The court basically says this argument unresponsive and not appropriate, dismisses that second standard as well. Third standard is whether there is irreparable injury by the denial of the return of the property. Once again, not at all in the docket, in the attention of this appeals court. Right after the break, I'm going to tell you more about that and then finish up with some wonderful exposition here. Stay with us. We are back doing our Saturday morning review, our analysis and discussion of great stories in law, government, and the aspiration for justice in America. Thank you for once again joining me and my producer, Kelvin, here. We're at the studios of the Shaw in Waukesha, downtown Waukesha, taking your calls and questions, as always, at 844-967-2789. In our first segments this morning, this special morning when we're celebrating, observing our 25th show, 6 months being on the air, we're spending some time talking again about the rule of law and this wonderful, this terrific civics lesson being given to America, and yes, also to a lower district court judge, and yes, indeed, to a former president about what equitable jurisdiction is all about, and also the basis for acting to try to upset, to interrupt a legitimate criminal investigation. Court of Appeals out of the 11th Circuit this past week saying we're having none of this and we're shutting all of this down, dismissing this challenge, permitting the investigation to go forward. Before the break, we were talking about these various standards that the Court of Appeals is using under this Ritchie case in the 11th Circuit. The third among those is whether or not the plaintiff, in this case the former president, is irreparably injured by the denial of the return of his property. Once again, the Court of Appeals not missing any opportunity to put Eileen Cannon in her place as the district court stepped in with its own reasoning where there was none before and identified potential irreparable harm that could arise. And the Court of Appeals goes on to dismiss all of that. As for records, the Court of Appeals says that may be otherwise sensitive. It cannot be that the Circuit Court says that prosecutors reading unprivileged documents seized pursuant to a lawful warrant constitutes an irreparable injury for purposes of asserting equitable jurisdiction. Simply can't be. Once again, this notion that after 240 years of doing this, it simply isn't the case that you can step in and stop prosecutors from looking at the documents to determine whether or not there is a basis for a criminal prosecution review by a federal grand jury. Here, too, the Court of Appeals goes on to say plaintiff's argument would apply to nearly every subject of a search warrant. The district court's unsupported conclusion that government possession of seized evidence creates an unqualified risk of public disclosure is not enough to show that plaintiff faces irreparable harm, dismissing that third standard under the Ritchie standards that it has articulated. Finally, the fourth of these standards, whether the plaintiff, again in this case the former president, has an adequate remedy at law for the redress of his grievances. Goes on to describe some of that, saying that he would have no legal means of seeking the return of his property for the time being and no knowledge of when other relief might become available. That's the position taken by the former president. Court of Appeals dismisses this again very summarily, saying this is not a sufficient justification, period. Goes on to say that under Rule 41, which applies after a case has been charged, you do have that possibility. You can go back into court and challenge the results of the search warrant. You can challenge the underlying probable cause for it, but not now. Plaintiff's argument, the appeals court says, would apply universally. Presumably, any subject of a search warrant would like all of his property back before the government has a chance to use it. Doesn't distinguish you, Mr. Former President, from everyone else in the United States of America. Goes on to once again to say that all of these arguments, all the arguments presented by the former president and embraced directly and indirectly by the lower court are a sideshow. That's the court's word, not mine. The real question that guides our analysis, the appeals court goes on to say, is this is an adequate remedy for what? In italics. The answer is the same as it has been in the past. Plaintiff has not asserted that any right has been violated, that there's been a callous disregard for his constitutional rights, or that a substantial interest in his property is jeopardized in any way. If there has been no constitutional violation, much less a serious one, the 11th Circuit says, then there is no harm to be remedied in the first place. All of that coming to the conclusion that there's no there's no basis here. And finally, a couple of very telling paragraphs, which, if nothing more, resound and provide us with civil instruction, criminal instruction about no one being above the law. I'm going to read this paragraph at page 20 of 20 pages altogether in its entirety, because it's so good to reestablish once again this notion that no one is above the law, including a former president, I would offer, including a present president, a sitting president. The Court of Appeals says this: only one possible justification for equitable jurisdiction remains, that plaintiff is a former president of the United States. It is indeed extraordinary for a warrant to be executed at the home of a former president. The 11th Circuit basically is saying, yeah, we recognize this is atypical. It's never happened before in the history of our nation. But not, the Court of Appeals goes on to say, in a way that affects our legal analysis or otherwise gives the judiciary license to interfere in an ongoing investigation. In other words, district courts, appeals courts, United States Supreme Court, not going to interfere. Part of the executive function, not a judicial function, at least not yet. To create a special exception here, the 11th Circuit says, would defy our nation's foundational principle that our law applies to all, without regard to numbers, to wealth, or to rank. What an amazing statement, appropriate statement, right statement to make, clearly establishing, again, no one is above the law. Finally, the Court of Appeals goes on to say this: the law is clear, period. We cannot write a rule that allows any subject of a search warrant to block government investigations after the execution of the warrant, nor can we write a rule that allows only former presidents to do so. Either approach would be a radical reordering of our case law, limiting the federal court's involvement in criminal investigations, and both would violate the bedrock concept of separation of powers. Accordingly, we agree with the government that the district court improperly exercised equitable jurisdiction and that dismissal of this entire proceeding is required. 21 pages of exposition by the United States Court of Appeals. A great lesson in civics this morning as we gather together to talk about that. What happens next? Court of Appeals opinion basically is effective now, but giving all the parties an opportunity. The case basically shut down effective next Thursday. We know that Raymond Dearie still out there, presumably until this order was issued, reviewing all these documents, giving the president also a chance, if he so decides, to appeal this to the United States Supreme Court, hoping that he does not, knowing that in a previous case, before this same circuit, before the same United States Supreme Court, he got nowhere and was told basically, we're not even entertaining this kind of challenge. If the president decides to go down that road, anticipate a Supreme Court supporting once again this very important, dramatic, but reasonable and balanced opinion by the 11th Circuit, shutting down after 3.5, almost 4 months of challenge to this search. And of course, all of this means that the investigation now goes forward. These tens of thousands of documents can in fact be reviewed now, not only for national security issues, but also to determine whether or not there has been a violation of the federal law in their taking from the White House, their acquisition, perhaps their use, all of that a part of the Department of Justice's continuing investigation into the Mar-a-Lago incident. That now being supervised, as I said before, by Jack Smith, who is the newly appointed special counsel overseeing all of this. That, along with the January 6th matter, separate from the Mar-a-Lago matter, but also brings us to the second major rule of law event of this past week. Also a civics lesson for all of us. Just this past week, we know that a jury in the United States District Court in the District of Columbia convicted the leader of the Oath Keepers militia of sedition charges. That happened on Tuesday of this week. Plenty of signal to the Department of Justice that its victory is significant, and that also served basically to ratify the government's central claim in the case. That, of course, that the Oath Keepers here were in fact this militia attempting to put together a scheme to overthrow the government. They were successful in winning 2 convictions on this seditious conspiracy charge. The most serious and perhaps politically inflected was brought among these 900 other criminal cases, also pending out there, people who were involved on the ground at the Capitol on January 6th. The guilty verdicts in this seditious conspiracy prosecution returned against this fellow named Stuart Rhodes. Again, he's the leader of the Oath Keepers. He's the #1 man in the organization, and one of his top lieutenants named Kelly Meggs, who ran the Oath Keepers Florida chapter at the time. 3 lesser defendants this past week, their names are Kenneth Harrelson, Jessica Watkins, and Thomas Caldwell, were found not guilty of sedition, which is kind of a rare situation given the fact that they're all charged in conspiracy. But everybody was convicted of at least 2 felonies and can expect to spend some significant times in prison. This is actually the first time a trial brought by the Department of Justice, again, among these many, many hundreds out there, that any jury has acquitted anyone of any charge related to January 6th. Attorney General, of course, responded to these successful verdicts, these successful prosecutions, and saying that the verdict in this case makes clear the department will work tirelessly to hold accountable those responsible for crimes related to the attack on our democracy. So why am I raising this? Well, not only is it a significant prosecution event of this past week, this is a huge, the most important case brought to date in the wake of January 6th. Criminal case by the Department of Justice, finding by a jury, a unanimous jury of peers, of people like you and me and others out there, looking at all this evidence and finding that indeed there was a basis for concluding unanimously that there was seditious conspiracy going on here. And the question now remains about 4 more Oath Keepers who are also still out there. They're still facing seditious conspiracy charges in another trial that's scheduled to begin next week. There's more of this going on. The question, of course, will a jury hold them accountable as it did these others this past week for sedition, even though none of these upcoming defendants were leaders of this group. This second batch of defendants coming up for trial, yes, this coming week, their names are Roberto Minuta, Joseph Hackett, David Morshell, and Edward Vallejo. They were originally charged with Rhodes and the others, but the trial judge, a fellow named Amit Mehta, who's presiding over all of this, decided that it was too cumbersome to try all 9 of these folks together, so he severed the trials out. So he's doing them kind of in sequence. The evidence likely to mirror what happened before in the trial of just this past week, and we'll see how that may go forward. Prosecutors may, in fact, explain during this upcoming trial how Mr. Minuta, again, probably the lead defendant in this second batch of defendants, who is a New York tattoo artist, was serving as a bodyguard that day for Roger Stone, someone we know well from our recent history, and also a longtime advisor to President Donald Trump. And yet, there's yet a third trial of Oath Keepers set for February, and the defendant in that case have not been charged with sedition, but that group concludes among its group Mr. Meg's wife, a couple from Ohio, and a former Broadway actor. All that coming up in February. And, of course, all of this a part of the government's response to January 6th. There is even more coming up, and that is in December 19th. There is yet another seditious conspiracy trial on the docket. 5 members of the far-right nationalist group Proud Boys, another group out there, the Proud Boys, set to begin on December 19th. And like in Mr. Rhodes' trial, the Proud Boys case will probably focus on the organization's leaders, among them a fellow named Enrique Tarrio. He's the group's former chairman, and some of his top lieutenants from Florida, Washington, and Pennsylvania. Likewise, the government likely to present evidence based upon all sorts of messages exchanged among the Proud Boys. The government believes to shows how the group moved increasingly toward violence to keep Joe Biden out of office. Likely includes some testimony also from 2 fellows named Charles Donahue and Jeremy Bertino. Both of them pled guilty in those cases, going to testify against their former co-conspirators, part of the government's case against the Proud Boys. All of that very, very significant as these cases go forward. And again, all of this in the midst of the government's continuing focus, not only on those who are focused on overthrowing our government on January 6th, but also a larger message that all of this premised upon the notion that this was not simply an engagement in legitimate political discourse, but rather instead a serious assault on our government. We're going to talk more about that and take your calls right after this break here on Morning Cannolis. We are back for our final segment in this first hour of Morning Cannolis, talking about law, government, and the aspiration for justice in America, specifically in this segment and the previous segment, talking about the lessons taken out of these recent convictions, these judgments to be entered against the Oath Keeper leadership, including Stuart Rhodes, and then the upcoming additional trials against more Oath Keepers in the coming weeks and months, and more immediately on December 19th. This much-related prosecution of the Proud Boys and its leader, a fellow named Enrique Tarrio, also in the federal district court in the District of Columbia. The government recently giving us some insight into how that case is going to be presented against Mr. Tarrio and his 4 defendants. Their names are Ethan Nordine, Joseph Biggs, Zachary Rell, and Dominic Pizzola. That they instigated others and ordinary rioters to attack the police on January 6th, leading to a series of breaches of the Capitol security, as we all witnessed on that day. Specifically, prosecutors signaling what they're going to be presenting in that December 19th trial, saying this: on January 6th, these defendants, these Proud Boys defendants, sought to harness the actions of others to achieve their objective of forcibly opposing the lawful transfer of presidential powers. In doing so, the defendants used these individuals, the other individuals, as tools. Once again, tools, the word used by the government to explain what it is they're going to be presenting at this trial coming up in just a couple of weeks, and then more trials down the road. Seditious conspiracy trials resulting in findings by impartial jurors looking at this evidence, finding that indeed this is not just tourists on that day. This is not just legitimate political discourse. This is not just legitimate First Amendment protest. This is sedition. And again, significant that a finding this past week in our nation's history, in the annals of our government, that finding made by a trial jury just this past week. Perhaps more of those verdicts coming up in the weeks ahead. We are always delighted to take your phone calls, take your observations and questions, and that includes Joe from Madison, who's calling in this morning. Joe, welcome to our program. Your thoughts, comments, or questions?
Thank you very much. There's just 3 points I'd like to make and get your reaction to. The first one was in your introduction where you said that you're highlighting your 25th show, which is fabulous, and you use the language, perhaps you'll keep going beyond that. And I would just say, Jim, please don't leave. It's perfect to have you on Saturday morning for our judicial cannoli.
No intention to do so. We'll see how the reviews come back on that, but looking forward to a long longevity here. Thanks, Joe.
All right. Let's gaffer tape you to the chair on Saturday morning for us. Thank you very much. I'm curious to get your reactions to 2 points. The first one is, I believe you've been speaking about this, which is the kind of language that's used in this particular document that was sent out. And one of the points you mentioned was that in the very first paragraph, you said they have the language, the answer is no. It's not a nuance, this or that, or this. The answer is no. Period. Another area, they were speaking about the judges' arguments, the lower court judges' arguments, and they describe it as, quote, a sideshow. It seems to me, ouch. And then in another point at the very end, the language was used, the law is clear. So there's no nuance or fudginess about any of this stuff. And I'm curious if you think part of this is to just state it out so directly that you can't keep coming back to it. And I not only for going out to the world and our country to sort of say this is how we view it, but also as a really big stop sign, as they mentioned several times within this, what you were describing, that anybody could then say, I want to stop the investigation because I'm going to be suffering irreparable harm. I need this material. It seems to me that those two things are interesting in terms of the kind of language was used and the fact of they got to put a stop to this or anybody and his brother can be doing the same thing, right?
Absolutely. And Joe, you should join me, as you often do on Saturday mornings, to expose just these kinds of comments you're making, all directly on point, spot on. So let's talk about the language once again. You bet. Courts of appeals, traditionally, and I've been on the receiving end of more than a few courts of appeals that have disagreed with things that the government has done, also approving things that we have done during my time as in the U.S. Attorney's Office. Courts of appeals tend to be very moderated. They will use words like, we tend to disagree, we have a different view of things. That, Joe, as you just indicated, that's not this opinion. This court is saying unequivocally, the answer is no. That's the second sentence in this order, going on to talk about just frankly, the wild, my word, not theirs, the wild invocation here of jurisdiction where there was none, basically saying that the lower court should have known better. No nuance in any of this. All of this is a sideshow, absolutely. That's kind of the language you'd expect maybe in a radio talk show from time to time, but not necessarily from an appellate opinion that remains forever in our annals of government. Undeniably a statement to Judge Cannon. And, Joe, as you indicated, a statement not only to the former president, to knock it off, if you will. Don't come back to us with these kind of spurious and, frankly, frivolous, a word they did not use the word frivolous, but could have used this word. Don't come back to us further. There's no there's no basis for doing this. And then the most important point of all, we've talked a lot about deterrence on this broadcast in the past. Deterring others. If you think this is a pattern for your future behavior, others out there, and there are thousands of people who regrettably every single week, every single month in this country are the subjects of search. This is not the remedy. You don't go in and file a civil lawsuit. You wait for your time inside a criminal prosecution. You don't do this. This is a stop sign, Joe, as you've just said, to everybody, not only to the former president, but to anybody who would think about doing this. And also a rebuke, if you will, to the lower court. Don't entertain this further. Get rid of this case, dismiss it, and move on. So undeniably picking up on that language again, not language that's completely unknown to an appellate court, but strong language also much in the media. These three judges, two of them appointed by the former president, President Trump himself, these are not folks who brought to this table a political agenda of their own. And these are folks who looked at the law and said this could not be clearer. And I would offer once again, the reason I've spent so much time on it this morning is because this document can be used, frankly, to teach civics. I realize a lot of this has to do with equitable jurisdiction, maybe things that people think lawyers love and are not beyond the scope of understanding. They are. They're very accessible. And the language of this, shutting this down, is, in fact, a great civics lesson to those people who might think about going into our state and our federal courts, advancing these kinds of spurious and unfounded allegations, bringing this hopefully to an end, even as the legal woes of the former president continue. We were chatting again right before the break into this segment about the seditious conspiracy case, also having to do with January 6th. We know as well that case brought by the Department of Justice is a part of a larger view being taken by the Department of Justice of everything related to January 6th, that being still pursued, arguably against the former president and his aides as well. We're going to talk about that and other matters on the docket of America right after the break in our second hour this morning here on Morning Cannolis. Stay with us here. Civic Media's The Shaw, WAUK in Waukesha.
Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Welcome to our second hour on this terrific Saturday morning, December 3rd, 2022. It is our 25th show, the conclusion of our first 6 months, hopefully many more months here on the studios of Civic Media. I'm in the Shaw, WAUK in Waukesha, 540 AM, 101 FM with my outstanding producer, Kelvin. And we are taking throughout this hour, as we always do on Saturday mornings, your calls, your questions, your comments, at 844-967-2789. Delighted, as always, to hear from you as we talk about these major stories in our nation and occasionally around the world in law, in government, and the aspiration for justice in America. In our first hour, we talked about this very significant case coming out of the 11th Circuit Court of Appeals, putting an end to the civil challenge against the continuing criminal investigation of the Mar-a-Lago documents case. Also talked about a very serious verdict, a very significant judgment now to be entered in the first of the Oath Keepers trials, alleging seditious conspiracy in connection with the January 6th riot, the assault on the Capitol. Others of those defendants coming up for trial in the weeks and months ahead, including others in the Proud Boys group, likewise going to be tried in front of judges and juries in Washington, D.C. We'll keep you updated on those matters as well. Again, sending this message that the events of January 6th were not simply the actions of 900 people, but were part of an organized attempt at sedition, which is the overthrow of our nation, attempt to undermine our government in attempting to ensure that the presidential election results are not endorsed and not presented properly to the United States Congress, an attempt that, as we know, was not successful. Nonetheless, the conspiracy to try to accomplish that, the result this past week of a verdict against some of these seditious conspiracy defendants, everybody facing felony convictions, facing felony judgments as a result of that. We're going to talk this coming hour about more cases in our federal and our other courts in America. Again, an ambitious but achievable agenda, including this criminal tax trial that's now coming to an end in a district court, a trial court in Manhattan. That's a state proceeding. As well, a grand jury proceeding having to do with January 6th and some significant appearances made by some individuals just this past week. And then also in a federal district court and also a federal appellate court in New York having to do with claims of sexual assault by the former president. Finally, in our last segments this hour, we're going to return to a common focus of our attention and our discussion, and that is the United States Supreme Court. Because this coming week, two major cases, one being argued on Monday, one being argued on Wednesday, that have the potential once again to change our view of civil rights, our structures, about the way in which we understand human rights in America, and also, no less significantly, how we understand and apply the trappings, the rules, the processes of voting and elections in America. That coming up in our later segments of this hour on Morning Cannolis. Let's talk first about this state criminal tax trial now going on and almost concluding in a trial court in Manhattan. We know that the Trump Organization on trial for a number of different related events, personal expenses being paid by the corporation without reporting income, compensating some employees as if they were independent contractors, other things related to perhaps two sets of books, all of them implicating New York state law in the area of tax fraud. And the question is whether or not the jury is going to find the organization itself, the Trump Organization, guilty of these state felonies for engaging in this financial tax fraud that has been the subject of this trial for many weeks now. Just this past week, as the trial has concluded, presentations, again, principally by the government and also by the defense, suggesting and then attempting to attack that suggestion that the corporation, the organization, is indeed liable, criminally liable for the fraud scheme, this 15-year tax scheme that the government, the state of New York, has brought. Joshua Steinglass, who is the principal Manhattan DA who has been prosecuting this case, told jurors in his closing argument just this past week that this scheme basically helped Trump's company keep salaries down, to also shift some tax deductions to Trump entities like Mar-a-Lago, and also reduce payroll taxes and keep executives happy and loyal. So providing something the juries always want to know, which is, what's the reason for doing this? What is the motive? You can establish intent, which is different from motive. Here they're also explaining to you why it is they had the intent to engage in tax fraud. This Joshua Steinglass, the assistant DA prosecuting this case, said this: the entire defense strategy, attacking, if you will, the government's case, here is to promote the notion that Alan Weisselberg, again, Weisselberg, the CFO who testified principally in support of the government's case, the entire defense strategy, Steinglass says, is to promote the notion that Weisselberg did it for Weisselberg. Has a nice ring to it, he said to the jury in his closing argument, but it's just not grounded in reality. Went on to say that the chief financial officer, of course, is to be believed, even though he pled guilty and testified for the prosecution. Steinglass going on to tell jurors that Trump executives other than Weisselberg were also involved. The chief operating officer, a former general counsel, receiving Christmas bonuses as if they were independent contractors. All of that, all a part of this fairly compelling closing argument made by the prosecution in this case. One of the lawyers for the defense told jurors in response to that Weisselberg's intent was to benefit himself and not the company. Why is that significant? That's significant because the government needs to prove in this case that Weisselberg's actions were done on behalf of, to support, to encourage, to advance some interests of the company. There's got to be that connection between Weisselberg and doing it on behalf of the company that is still on trial for this. A woman named Susan Nescheles, who is one of the lawyers for the defense, for the corporation, for the company itself, just said that Weisselberg was acting out of greed and was embarrassed about betraying the trust of the Trump family, she said in her closing argument, for whom he had worked for nearly 5 decades. And so alleging that Weisselberg himself has some motive to testify, that his testimony is not to be believed. Also, of course, invoking the notion that he himself has pled guilty, going to be spending some time in state prison, likely for this offense conduct. And again, Steinglass press responding to all of that, highlighting Weisselberg's testimony, the fact it's corroborated, saved hundreds of thousands of dollars by covering about $7,000 in monthly rents on a luxury Manhattan apartment and other expenses. All of that a part of this sort of double books approach, back and forth by the attorneys for the government, by the attorneys for the defense. That's what happens in closing arguments. Now going to the trial jury to determine whether or not the corporation, the organization itself, which is the remaining defendant in this case, is in fact guilty of the offense conduct, this 15-year tax fraud scheme, anticipating likely a verdict from that jury, probably sometime in the days ahead. We can't say for sure. But plainly going to be a significant event if, in fact, the corporation, the company itself, found guilty of a felony in state court, plainly, undeniably impacting its ability to move forward. Understand, too, that this particular prosecution, a criminal prosecution by the DA, a fellow named Alvin Bragg in Manhattan, is different from, discrete from, but plainly somewhat related to the civil litigation being brought by the New York Attorney General named Letitia James. She is seeking about $250 million in a civil lawsuit against Donald Trump himself, the three Trump children, and his company for overstating asset values on properties and other residential ownership pieces in New York City. All those based upon what she maintains are fraudulent bank loans, insurance coverage, premised upon his inaccurate and deceptive valuations of those properties. This criminal prosecution, separate from that civil case, which is also going ahead among the former president's many concerns, legal concerns out there these days. And then in that connection as well, returning once again to January 6th, something we don't know a whole lot about in terms of substance, but significant in the rule of law because it happened this past week. We know that there is at least one federal grand jury, apart from the January 6th committee itself, a federal grand jury in the district court in Washington, D.C., that is investigating what happened with January 6th. Beyond the 900 people already being prosecuted for their on-the-ground offenses, beyond the seditious conspiracy charges against the Proud Boys, against others out there, the Oath Keepers, those trials coming up soon. We know that there's a federal grand jury that's also looking at people at the top. Who is in charge of this? Who is sending messages to others, including some of these other defendants, that resulted in the January 6th insurrection, the riot on the Capitol? That grand jury looking at all of this, including presumably things like the false electors case as well, coming out of Wisconsin and other states around the country. Why is this significant? What happened just this past week? Well, we know that just this past week, there were two important appearances by Pat Cipollone, the former White House counsel, and his deputy, Pat Philbin. They were appearing just this past week in front of a federal grand jury investigating all of this. Now, the reason this is significant is that, of course, Pat Cipollone, you recall, will have testified before the January 6th committee, the House committee, but declined to talk about specific conversations that he had with the former president based upon attorney-client privilege and perhaps other privileges as well. This was a subject now of some discourse, some disagreement, some argument before a federal district court judge. Her name is Beryl Howell. She is the chief judge in the District of Columbia. And just previous to their appearances before the grand jury, the judge resolved those privilege matters and said, no, you've got to appear in front of the grand jury. You've got to talk about what the president and presumably others said to you in connection with January 6th. We don't know, and we may know at some point down the road, but grand jury transcripts not produced immediately. We'll see down the road what comes of that, but the testimony itself in front of this grand jury just this past week, another major milestone in justice in America. Stay with us as we talk about yet more events in the courts of our nation here on Morning Cannolis. continuing to engage with me in our discussion, our review, our travels through major events in the rule of law this past week, including just before the break in our first segment in this second hour, a review of the Trump criminal tax trial in the Manhattan District Court, that coming to a conclusion fairly soon, perhaps anticipating a verdict in the coming weeks of the coming days of the coming business week, and also an appearance by Pat Cipollone and Patrick Silbin, the former White House counsel, and his deputy before one of the grand juries investigating the January 6th events and other matters related to that. Significant just because their appearances up to now have presumably been somewhat restricted by their invocation of privilege, something that the district court effectively resolved, permitting that testimony to go ahead this past week. We will find out, presumably at some point down the road, what the results of that testimony has been. Also this past week, in yet another grand jury, this one investigating the Mar-a-Lago matter, getting back to those very first issues coming out of Mar-a-Lago and South Florida. Another grand jury hearing testimony from the former media director Dan Scavino and the former deputy director of presidential advance, a fellow named William Russell, and Bo Harrison. All of those people appearing before a federal grand jury investigating the handling of classified documents found at the Mar-a-Lago estate. So those testimonial appearances also happening in Washington, D.C., even as we said at the top of our 2 hours this program, this morning in our program, the 11th Circuit clearing the way for that investigation to go forward full speed, perhaps involving at some point down the road a return by a grand jury of individuals responsible for that. Lots and lots of things going on in federal grand juries in the United States District Court for the District of Columbia. We'll watch all of those for you. And then moving back to New York and a combination of both state and federal courts. Let's talk again about E. Jean Carroll. We have chatted about her on this broadcast in the past. You may recall well that she brought initially state court action against the former president while he was still the president for defamation. She had alleged in some publications that he had assaulted her in a department store in New York way back in the 1990s. The president, while he was the president, had allegedly defamed her by saying that she's a liar, said other things about her, and she brought a lawsuit initially in the trial courts in New York, ultimately removed by the United States Department of Justice into federal court on the basis that Donald Trump was acting in the scope of his federal employment in saying those things about E. Jean Carroll. Well, this past week, that issue of whether or not the removal of that case from state court to federal court and effectively the substitution of the United States of America for Donald Trump was proper, that before the D.C. Court of Appeals, the Washington Court of Appeals, determining whether or not a president saying these kinds of things while he, or perhaps one day she, is in office, whether those kinds of things are in the scope of their employment such that this case is properly removed, this United States substituted, and the reason why that is significant is that you can't obtain a judgment against the federal government for defamation. Those arguments made just this past Thursday in front of the United States Court of Appeals for the D.C. Circuit. Very significant in terms of what the future may hold for that case, but also for this notion of what a president does and does not do in the scope of his or her personal and official capacities. This is what the attorneys for E. Jean Carroll said to the Court of Appeals, said that Trump and the Department of Justice, for their part, have responded to these developments by asking this court to announce a categorical rule that elected officials always and automatically act within their employment whenever they address the public. The attorneys for E. Jean Carroll went on to say this court should reject that position and hold that the former president acted outside the scope of his employment when he repeatedly defamed E. Jean Carroll in June of 2000. 2019. Went on to say this: Trump's defamatory statements targeting Carroll after she revealed that he had raped her that those were outside of his employment as president. He acted with private motives, E. Jean Carroll's attorneys say, not in furtherance of any official federal purpose or function, in seeking to punish and humiliate Carroll for revealing his decades-old crime. So that matter now before the Court of Appeals of the Second Circuit. They'll determine whether or not this case is properly in federal court or should go back to state court. Significantly, as you well know, as we reported on this broadcast in the past, E. Jean Carroll has also brought a second case under New York state law, that under the New York Adult Survivors Act. She claims defamation, same predicate, but different kind of statement by the president recently under his new social media platform, again alleging that this never happened, alleging that she is lying, and also she alleges battery under this new law in New York that allows an adult assault victim to file claims that would otherwise be barred by the passage of time. So that new lawsuit filed, again pending in state court, the parallel to this federal case now before the Court of Appeals. And to make this even more complicated, that federal case still going ahead in the district court. We know that the former president was deposed at least once in that matter, permitted by the trial court judge. All of this happening in New York, variously in and out of federal and state courts, premised upon these allegations of assault way back in the 1990s, and again, alleged defamation by the president recently, very recently, and again, while he was president. Lots to take in there, lots to look at, lots to monitor as we go down the road. Let's begin to take some additional callers here. Dick, thanks for calling in from Madison. Thanks for being a part of our program this morning.
A little off topic, but you were talking about the situation with the Oath Keepers and the Proud Boys earlier. And I read something about a week ago about something I didn't even know about that happened in 2018.
And Dick, you know what I'm going to have you do? I'm going to have you keep that thought because I'm going to do a small break here. I want you to stay with me, if you will, and I'll take your question right after this break, and we'll talk more about those Oath Keepers and other things that you saw recently. Stay with me, Dick. We are back here on Morning Cannolis. We're chatting with one of our good callers, Dick from Madison, has called in. Dick, right before the break, we were beginning to chat with you about something that you read in connection with the Oath Keepers, Proud Boys, and wanted to resume our discussion with you. Your comment or question right before the break. Go right ahead, Dick.
Well, it dates back as far as 2018, and then they had intervened in a situation with a club I'd never heard of, the Metropolitan Republican Club, that was founded way back in 1902, and they were supporters of Theodore Roosevelt. But these two guys were actually convicted and sent to prison for 4 years that long ago. I guess my question is, they point out in the article that the party / the country has survived other extremist right-wing groups like, the Birch Society back in the 60s, but this group seems to be, both of them, just a little bit wilder, crazier, and, for lack of better words, resilient.
Right.
What is it going to take, James, to shut these people down?
Right. And I think your concern, Dick, is one that many people, all people of all parties share, regardless of your political persuasion, because, again, the evidence in this trial just now concluded show that they were ready with weapons across the river. They were ready to come in upon instruction from someone, maybe the former president, maybe other people. This was going to be it was an armed assault on the Capitol, but even more than that, these were folks who were quite literally, as the charge alleges, trying trying to overthrow the government. What will it take? It's more than a rhetorical question, right? To send that message that not only are these people, should they be stopped, but others who might do the same kind of thing. This is not America, and the message has got to be out there that if you engage in this kind of behavior, you will be on the receiving end of an indictment. We are hopeful that these additional prosecutions coming up of Proud Boys, of the Oath Keepers coming up in the next few weeks and few months, send the same messages. The juries looking at this will say, this was not simply people misguided on January 5th or 6th. These are people who intended to undermine and overthrow our government to stop this. And again, the evidence quite compelling, not only in support of conspiracy, but their overt acts undertaken in an attempt to try to accomplish just that. Very, very important comment. Appreciate that call very, very much. And also appreciate Matt calling in this morning from Madison. Appreciate your being a part of our program this morning. Matt, your comment or question as well.
Hi, Jim. It goes back to the Mar-a-Lago documents.
Yes.
It's actually has to do with the social media, too.
Yes.
What do you make, or what is the usefulness of Trump effectively admitting, I think it was on Truth, where he said, I took the documents, right? Like,
Right.
I'm hoping that in the course of this trial, we can jump past the did he do it or not,
Right.
and move right on to their, in my opinion, inane argument that he was allowed to.
Right.
Is that accurate? I'll take my answer off the air.
Absolutely. Great observation. Again, not only in the media, but reported from the president's own pen, his own social media platform. I took the documents. That is also out there. People often think that just because it's on social media, well, gee, somehow it's off. It's not appropriate to present that during the course of a trial. Just the opposite. Social media, you make statements on social media, whether it's on Twitter, it's on Truth Social, whatever your platform is, can in fact be used. I often say on this broadcast and others that when the president sat down with Lester Holt many years, months ago now, and said that, yes, I fired Jim Comey because of that Russia thing, he's admitting to obstruction of justice. And just because he does it in a news format, in a public format, doesn't mean it cannot be used. And you're absolutely right, Matt. That's the kind of thing that if I were Jack Smith, I am not, but he is very, very good. He knows this well. Anticipate that kind of thing will be presented if indeed the president and others are indicted for the Mar-a-Lago events. That is clearly a statement, not only contrary to his interest, but it implicates him in doing that. He understood what he was doing. He took them. Now there's more to the case, obviously, but that provides a significant, important predicate for going ahead. You got to believe that Jack Smith took a note of that. It's a part of the government's file now as a grand jury looks at this, as Jack Smith and all the staff looking at Mar-a-Lago continues that investigation. A great point made. Very much appreciate. Thank you for that observation as well, Matt. Let's, in our remaining moments and time together this morning, turn to another building also on Capitol Hill, and that is the United States Supreme Court. We have spent a lot of time in previous broadcasts talking about some of the major cases, 10, 12 cases pending in front of our high court in this term, the 2022-2023 term. And those include, plainly, a number that are going to affect the ways in which we live, our lives, our livelihood in America. Just this past week, the United States Supreme Court said that it will add to its docket, just right now in excess of about 40 cases altogether, add to its docket this issue related to whether or not President Biden's decision to implement this cancellation of student loan debt initiative affecting quite literally millions of people in America, challenged in lower courts and overruled, vacated, basically on the basis that the courts found that this was an inappropriate exercise of executive authority, whether or not those lower court rulings stopping that initiative from going forward, stopping the Department of Education from reviewing applications, from taking applications on this student loan cancellation program, whether that is appropriate or not. The Supreme Court just this past week, upon the petition of the president through the Department of Justice, has agreed to review the legality of that cancellation program involving millions of borrowers, as you well know. ago. The case coming out of the 8th Circuit in particular, brought by a group of 6 states, Iowa, Arkansas, Kansas, Missouri, Nebraska, South Carolina, all challenging that plan. Oral arguments set now before the United States Supreme Court for February. A decision likewise, as it will be in these other cases, anticipated probably by May or June. And again, the difficulty in all of that, of course, is it stops this process from going ahead. The fact the Supreme Court's going to take it on is significant, but we'll have to wait now 5 or 6 months before that initiative can be either determined to be constitutional, in which case it goes ahead, or if the Supreme Court says something else and determines that the lower courts are accurate in finding that the program needs to be stopped. 2 other things coming up just this week, and I want to spend our remaining moments here this morning on Morning Cannolis talking about the future, the days just ahead. 2 major cases that we have talked about on this broadcast in previous Saturday mornings, one of them having to do with civil rights and human rights, the other having to do with voting in America, elections. Who decides elections? Who decides the results, processes, and procedures as well? On Monday, December 5th, the United States Supreme Court is going to be hearing oral argument in a case called 303 Creative versus Elenis, E-L-E-N-I-S. And again, we have talked about this case in prior broadcasts. We know from the past broadcasts, but more importantly, from documents filed in the United States Supreme Court. And we'll hear again about this in the argument before the United States Supreme Court this coming Monday morning, that the principal petitioner here, a woman named Smith, who is the provider of wedding support services. She provides wedding websites out of Colorado for clients, providing information about ceremony details and pictures, stories about the couple, often including a biblical quote celebrating how marriage through that process that individuals become one flesh, according to her website. She has not, however, agreed to serve same-sex couples and provide that website service to anyone who is a same-sex couple in the course of their wedding preparation. Now, there's a Colorado law, a Colorado civil rights law that prohibits discrimination based upon many immutable characteristics, including, yes, indeed, sexual orientation. And it is that state statute that the government of Colorado has said that Ms. Smith has violated by failing to provide services to same-sex couples, and also posting boldly on her website that she refuses to do so. And that's significant because what the Supreme Court is going to be deciding in this case, focusing in particular upon free speech and this First Amendment notion. The stakes are very high in this case, as you can well imagine. Basically pitting, if you will, the right of LGBTQIA members of that community to seek goods and services from businesses without discrimination against, if you will, the right to free speech under the U.S. Constitution, the First Amendment. Smith herself says this. She says, Colorado is compelling and censoring my free speech, forcing me to design and create custom artwork that celebrates messages that go against my deeply held beliefs. My faith is at the core of who I am. That is her position as she goes forward and argues this. Now, as I indicated, the Supreme Court has limited its review of a lower court decision coming out of the appeals court that is found in favor of Colorado, has said, yes, indeed, the Colorado law should in fact be forced in this way, and Ms. Smith cannot do this in violation of that state statute. So she is appealing this. She is maintaining that not only does she have the right under the First Amendment to pursue her business as she wants to, but that the law itself should not prevent her from doing that. And the Supreme Court, while this case is involving plainly both faith and religious beliefs, as she has described it, and also First Amendment rights, has limited it pretty much to the First Amendment focus. Now, as a practical matter, on Monday, highly likely, that the United States Supreme Court is going to be addressing all of these things. It's hard to separate out all of those First Amendment concepts. As we know, First Amendment providing freedom of religion, both in terms of establishment and exercise of it, and also free speech. And so all of that coming up this coming Monday before the United States Supreme Court. The court also plainly working in the wake of its previous case that many of you will recall well. Previously, when the Supreme Court, in a legal battle way back in 2018, addressed whether or not that same Colorado anti-discrimination law applied to a fellow named Jack Phillips. You may recall he was this bakery owner in the Denver area who refused to provide services to same-sex couples. He was making cakes, not websites, but cakes. And in the end, the Supreme Court heard oral argument on that issue, decided not to resolve the issue of whether or not the First Amendment rights are greater, the First Amendment rights to religion and to free speech are greater than the rights of individuals, including those of the LGBT community, to engage in commercial enterprise, to do that in a non-discriminatory fashion that does not prohibit them from engaging in all the other things that others do in America. The Supreme Court, in the end, didn't really resolve that issue, basically sent it back to the Colorado authorities at that time, determining that Colorado officials at that time had violated the Jack Phillips religious rights by not giving him the process, the procedural rights he'd otherwise have, carving out an exemption for him under the anti-discrimination law. So didn't really resolve the issue. It is back. It is back again in this case coming up on Monday, 303 Creative versus Elenas, determining whether or not which one of these interests is the greater interest. We know from our past discussions and the past history of the United States Supreme Court that it is very common for them to take on religious cases. Interesting that here that they have carved out the religious aspect of it somewhat, but nonetheless taking on this case to determine whether or not which one of these conflicting interests, if you will, preside and which one are take precedent over the other. My own view is that they both can live together, right? The Colorado authorities are saying, we're not telling Ms. Smith not to abide by and follow her own views that she has under her own faith and her own spiritual beliefs or religious beliefs. But what she cannot do is engage in discriminatory conduct, behavior as to a significant portion of the population, the LGBTQIA population, in particular same-sex couples. That's their position. Seems to me that those things can be reconciled without doing violation to either one of those. And we'll see. We'll see on Monday how the Supreme Court comes down. We know that the Supreme Court has often sided in favor of religious positions in the past, and will determine down the road, presumably in May or June, which one of those seemingly competing interests holds sway when it comes to resolving this case, 303 Creative versus Elenas, coming up for oral argument this coming Monday morning on the 5th. As we come back for our final segment, another case before the Supreme Court this coming Wednesday. Stay tuned for that discussion right after this break. Here in Morning Cannolis, our discussion of law and all things justice, the aspiration for justice in America. In our final moments here today, my discussion, my presentation to you about another case that we have talked about before, pending before the United States Supreme Court. Strong encouragement, if you have the time, if you've got the interest, and I know you all do, in hearing what our Supreme Court is thinking about these major cases, including this case coming out of Colorado that we talked about right before the break. That case is going to be argued this coming Monday morning. And And then this coming Wednesday, the 7th, also at 10 o'clock Eastern Time, 9 o'clock Eastern Time, you can hear it live. You can also hear it recorded down the road from the United States Supreme Court on their website as well. Listen to the voices of the Supreme Court justices themselves as they question the attorneys for the parties in all of these cases. All of that accessible online, live, and then also recorded down the road. The second case I want to highlight for your attention, this is the matter that I've identified, and I think many other people who are also focused on the Supreme Court have identified as perhaps the most significant case of this term, arguably in recent years, not in any way diminishing the impact of a recent civil rights cases involving privacy rights and abortion and guns and environment and many other things. This case is called Moore versus Harper. Moore versus Harper. Again, we've chatted about it in the past. It comes out of North Carolina, as other states have done, including Wisconsin, in the past election cycle, in the past census cycle. North Carolina draws new lines for its congressional districts, also state assemblies, state senate districts, and along the way, our legislature draws lines in such a way that, according to many people, disenfranchises people of color. Gets up to the North Carolina Supreme Court, and the North Carolina agrees with those folks and says, you know what, these lines that you have drawn, legislature, do in fact compromise the right of people to vote, the right of people to gain access to the polls, and so go back and do it again. The North Carolina legislature says, nope, we're not going to do that. Not only did we not violate the Voting Rights Act, not only have we not discriminated against, not disenfranchised people, but beyond that, and here's why this case is so very important. In this case, Moore versus Harper, the legislature coming out of North Carolina says the North Carolina courts have nothing to do with this. The North Carolina Supreme Court, lower courts should not be involved at all in matters related to the times, places, manners, anything having to do with elections in America, including in North Carolina. They use this argument premised upon what's called the Elections Clause in the Constitution. It's Article 1, Section 4, and it says the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may from time to time alter or make such regulations as it may feel are appropriate. They use that language, again, consistently interpreted to mean that state legislatures set the rules in states for elections. We know that. That's true in Wisconsin, every other state in America. To say that the courts have no involvement in this at all. And along the way, this doctrine called the independent state legislature doctrine is advanced. A doctrine that has been explicitly discarded by the Supreme Court on at least 4 previous occasions when it's addressed this. A doctrine that can only be regarded as a fringe doctrine, not embraced by anyone with a sensitivity and an understanding of our Constitution. A doctrine that, as many people have observed, and I've observed as well, tends to stand elections on their head. And the key to this argument is that this exclusivity of the legislature's authority would basically be contrary to, again, 240 years of our own laws, that the courts themselves would not have the prerogative to intervene and determine whether or not processes and procedures and rules and laws for conducting elections are appropriate, that huge, but also could make decisions based upon their own views about what happened during the course of those elections, make determinations about who actually won. So kind of a twofold threat to democracy under this. State courts cannot change what the legislature has enacted. That's what this doctrine says. And it's only the legislature that can decide whether or not the courts are making a change. So that in Moore, this case pending before the Supreme Court, the question is whether North Carolina Supreme Court allegedly improperly supplanted the gerrymandered districts by that state legislature. The theory, as it's applied here in this case, effectively, as I indicated, upends our traditional notions of judicial review, where the legislature sets the rules, but the courts always, for two centuries, have served as the ultimate arbiters of statutory and constitutional interpretation. That is a significant change. And the fact that the United States Supreme Court is even taking this case on should give us all pause, regardless of one's view, regardless if you're a Republican, a Democrat. This goes to the very legitimacy of our elective process, our polling, our voting. The second reason why this is so very significant, not just for North Carolina, not just for the voters there and the lines that are drawn there, is because it applies plainly to all states, not just North Carolina. This independent state legislature doctrine opens up the possibility that the state legislature can overturn the decision of a duly empowered state elective office, election officials, in deciding whom to seat, not only in our federal legislature, our congressmen and women, our senators as well, but also, of course, presidential electors. Could substitute, if you will, the decisions of the voting population in a particular state, Wisconsin, North Carolina, could substitute their own view based upon what? Well, perhaps coming forward and saying, well, we've got some concerns about fraud, something else identified in the state legislature, substitute their decision for the decisions of the voters. A great concern, as I have said before, in this Moore versus Harper case, the Supreme Court is even entertaining this, could change dramatically, not just the elections going forward in 2023 and 2024, but also for all time, could change again in the Electoral College how our electors are chosen, how the numbers are sent to Washington, D.C. Again, a real threat to our future democracy. People on all sides of the political aisle should be very concerned about this, and they are. Listen in on Wednesday morning at 10 o'clock Eastern Time, 9 o'clock Central Time to hear the Supreme Court justices wrestle with this issue. We'll get a pretty good sense about how they're going to decide this case down the road. Moore versus Harper. We'll chat about that more down the road as well. And finally, in our closing moments here on Morning Cannolis, want to reaffirm what my good colleague and friend has told you along the way. That's Don Brown, talking about his plans tomorrow afternoon beginning at 3 o'clock to provide not only color commentary, but encouragement to all of us when it comes to the parade here. I'm going to be around as well. The parade here in Waukesha, the Christmas parade, resuming at 4 o'clock. Be a part of that coverage, whether you're in person, whether you're a part of our broadcast tomorrow afternoon as well. For today in Waukesha, have a good day, everybody. We'll see you tomorrow and again next Saturday morning. Take care.